Hello YouTube, Bane666 here. So my last video was about the young Turks and about their particular style of journalism, so-called journalism.
Terrible, shoddy journalism.
Where they basically go to some online media outlet which agrees with their particular style of politics, you know, something like BuzzFeed or Raw Story, or in the case we're about to see, Think Progress. They read the article on this particular website without checking any citations or seeing if the information is accurate or unbiased. They just take it as fact without doing any research whatsoever.
No, you didn't do any research, did you?
And then they rant and rave about it for a good 10 or 15 minutes, outraged at the injustice being done. All the while patting themselves on the back, telling themselves that they're the good progressive alternative to the corrupt media. To me, it just seems like they're a bunch of lazy assholes. And today I have another example for you. Take it away, Jenk.
Betsy DeVos has a brilliant new idea. She's reconsidering some of the policies in the education department, and Title IX guidance on campus rape and sexual assault is among those. And so she's going to meet with some leaders who care about that issue, and she's decided to meet with leaders who also don't care about that issue, or care about it in a different way where they think it should be de-emphasized.
So here we see Jenk constructing his straw man right from the beginning. So before he continues with constructing the straw man and derailing the conversation and talking about irrelevant things, let's have a look at an actual example of why MRAs care about what's happening on college campuses and Title IX.
Good evening, everyone. New at 6, victory for a University of Cincinnati student accused of sexual assault.
A federal appeals court ruled that student was denied the right to confront his accuser. 9 on your side, Chief Investigative Reporter Craig Cheatham has the exclusive details on the court's ruling and its potential impact. Craig
and Tanya, as a result of that, the court said that the university should not have suspended the student. The attorney for the accused student says this is the first time an appeals court has ruled that a student has the right to confront the accuser in a college disciplinary hearing. In this case, a UC graduate identified as John Doe said the university denied his right to confront the woman who accused him of sexually assaulting her. The alleged victim, identified as Jane Roe, did not appear at the hearing and was not available through a conference call or remote video. The UC disciplinary panel hearing the case relied primarily on her written statement.
He was fighting against a piece of paper.
Attorney Joshua Engel represents the accused UC student, identified as John Doe.
The accused, the graduate student, never had an opportunity to ask questions of his accuser. And if he had been given that opportunity to ask questions, he might have been able to point out inconsistencies in her story or possible bad motives.
In today's ruling, the U.S. Sixth Circuit Court of Appeals found that the University of Cincinnati's disciplinary panel decided the accused's fate without seeing or hearing from Jane Roe at all. That is disturbing, the judges said, and in this case, a denial of due process. The judges also added that failure to confront any form of confrontation of the accuser is fundamentally unfair. Joshua Engel expects the ruling to have a broader impact on the way colleges and universities discipline students.
It's the first time that a court of appeals has said that there is a right to confront your accuser in important disciplinary cases in schools.
I don't think Tyler had the right to face me.
Former UC student Jennifer Shoei said she was sexually assaulted by another ex-student named Tyler Gishel. Gishel said the sex was consensual. Shoei says that the accused should not be able to confront his accuser during a university code of discipline hearing.
It makes us feel so violated all over again.
Jennifer Shoei and Tyler Gishel are both suing UC, claiming the university violated their rights to due process during the handling of their case. UC declined to comment on that case. 20 minutes ago, we received a statement from UC about the appeals court ruling in a different case. UC says it is reviewing that decision, and UC emphasized that its commitment to providing the best environment for all students transcends everyone on campus, and that it's committed to creating a culture that values consent. And I might add that the student who was disciplined in that case was suspended, but they got a stay, and that student has remained on campus and has not been suspended. Back to you.
Okay, so that's the issue here. Now, for the record, I think it's crazy that universities are holding hearings about rape cases. This is something that should be done in a court of law. But if universities are going to hold hearings about rape cases, then the accused should have basic due process rights. They should be able to face their accuser. They should be able to have legal representation. They should be able to present evidence and to see all the evidence against them. These are basic legal rights. That's why MRAs are pissed off about Title IX and the way it's misused. Because there are new cases popping up every day on university campuses where accused men are prevented from having their basic due process rights. So we have a choice here. We have a choice between two different things. The first option is that we can have a system in which everyone, regardless of gender, regardless of sexual preference, regardless of race, regardless of religious affiliation or political affiliation, everyone gets due process rights, regardless of what they've been accused of. Everyone, right? That's option one. Everyone gets a fair trial. I don't care if you are accused of rape or being a terrorist or whatever, right? It doesn't matter. Everyone should get due process rights and a fair hearing. And then there is option two. When a woman makes an accusation, we should just take her word for it, because women rarely lie about anything, apparently, especially in a court of law, and especially about rape. So therefore, we should just make the assumption that the accused must be guilty. We should do away with due process rights because, you know, they're just a hassle, and they stand in the way of actually punishing the guilty because, well, we know that the man's guilty because he's been accused, right? So there's no need for due process. Think of the victim. That's what's important here, is the victim. And we know she's a victim because she says she is, and that's good enough. So we have an option between these two things, and MRAs clearly want option one. We'll see which one Cenk wants as the video goes on. But he actually doesn't spend that much time talking about the actual issue, which is Title IX and rape on campus. He spends more of his time taking a massive shit on MRAs. So let's get stuck into it.
So let's give you details on those meetings. Think Progress reports, after months of receiving requests for meetings from advocates for sexual assault survivors, Education Secretary Betsy DeVos has finally decided to sit down with them. Good news. But she's also meeting with groups that are critical of Title IX guidance on campus rape, some of which have histories of intimidating rape survivors and dismissing domestic abuse against women.
Oh, okay, so she's listening to both sides of the argument then. Is that what you're saying? And that's a bad thing, apparently. Well, of course, Cenk thinks it's a bad thing because he's read a bias hit piece on men's rights activists and he's taking it at its word without doing any research. Basically, the extent of his research is reading this bias article. That's it. End of story. Well done, Cenk. Well done.
Now, I'm sure that they would disagree with that characterization, but let me give you some of the details and you make up your own mind.
Yes, I'm sure they would disagree, Cenk, which is why maybe you should have reached out to them for a quote, you know. Maybe made a phone call, maybe asked their opinion, maybe asked them to clarify a few things.
The department reached out to National Coalition for Men, SAVE, that's Stop Abusive and Violent Environments, and Families Advocating for Campus Equality. Now, some of those groups sound reasonable. I mean, why wouldn't you want campus equality? Certainly progressives would. And some of what they do is not outrageous. So if someone has been falsely accused of rape, protecting that person is a good thing. And no one wants false accusations of anything, let alone something as important as rape. Now,
oh, you agree with us, Cenk. That's great. We should be able to just end the video here, right? No need to go on and talk about anything else. We can just stop the conversation right here because you actually agree with the men's rights talking point, right? You're for due process, just like us, correct?
The reality is that does not happen very often. I'm going to give you the stats on it a little bit later.
So Cenk is referring to false allegations not happening very often. I'll address that later on when he presents his statistics. But what about the actual issue here, which is due process at universities? How often is that violated? Well, let's have a little bit of a read of a recent article by the Washington Post.
Campus due process in the courts. About one new due process lawsuit per week was filed last year against a college by a student who had been found guilty of sexual assault by a campus tribunal, despite what the lawsuits claim is strong evidence of innocence. This estimate comes from Samantha Harris, of the Foundation for Individual Rights in Education, FIRE. With the federal government, campus activists and many faculty members and administrators pressuring universities effectively to presume the guilt of accused students, that one per week rate has continued into 2017. The most recent lawsuit was filed last week by a former Purdue ROTC student. Many of these lawsuits continue to work their way through state and federal courts. But there have been more than 50 decisions in lawsuits filed by accused students since the Obama administration mandated in April 2011 an array of procedures designed to produce more guilty findings. The accused student has prevailed in around half of these cases, although generally only in a preliminary motion, followed by a university settlement. This record allows for some generalizations, in what is a surprisingly unstable area of the law. The lawsuits have employed differing theories, involving claims of gender discrimination, due process violations at public universities and breach of contract. But at the most basic level, each has asked judges to recognize the depth of the unfair procedures employed by the targeted university. These decisions come against a long-standing historical background of judicial deference to campus disciplinary judgments, which in the past often involved allegations of academic misconduct. Judges appropriately concluded that professors were better able than jurists to determine what constituted plagiarism or cheating on exams. We doubt, by contrast, that university bureaucrats deserve similar deference when they undertake to decide whether their students have engaged in behavior that's a felony in all 50 states.
As I said earlier, rape should be handled by the authorities, by the legal system, not by universities. When rape cases are handled by the universities, one of two outcomes happens. Either an innocent man is kicked out of a university, or alternatively, a rapist is kicked out of a university but does not go to jail, because the universities do not have the authority to sentence someone to jail. And if someone has actually committed a rape, they need to be in jail. They deserve to be in jail. And in my opinion, either of those outcomes is not justice. You either have an innocent person being punished or a guilty person not being punished enough. And this is why rape should only be handled by the legal system, by the justice system, in a court of law with due process. It's that fucking simple.
And there's a good argument to be made that some of these groups are not worried about just protecting innocent victims of false accusations, but think that the issues of campus rape and sexual assault are a little overdone. Okay, so let's dive into the details and figure it out together. The National Coalition for Men, which was founded in the 1970s, has a long history of what is known as men's rights activism.
You'll note the quotation marks around men's rights activism. So whenever you see this in an article, you know that the person writing the article does not consider the men's rights movement to be a legitimate movement or men to have legitimate issues that need to be dealt with. So we can conclude that the article is coming from a biased, ideological point of view. But continue, Cenk, continue.
One of the group's chapters published the photos and names of women while calling them false accusers. Now, if it turns out that the whole thing was adjudicated and they went to court and it was shown that they are in fact false accusers, okay, I'm more worried about the guys who are falsely accused and you want to have some protections for them, that's great. But publishing the pictures of those women, I don't know how necessary it is or how helpful it is, but you can make a case for it. I wouldn't do it. It's not a close case for me. But if you're in that group, I guess I get it. But did you really make sure that those were all adjudicated, or did you start putting up pictures of women who had rape accusations, some of which might have been true, and then you put their picture up as, false accusers?
Now, I have to actually agree with Cenk here. If the photos are of people who have been found guilty of making false allegations, you know what, I've got no issue with the National Coalition for Men putting up their photos. As far as I'm concerned, people who have made false allegations of rape and it's been proven that they've made false allegations of rape, by all means, expose those fucking assholes. Don't have an issue with that. However, if this is just accusations of false accusations, that's a different thing altogether. So maybe we should answer that question. So let's follow the citations and see what we find. The Young Turks video leads us to the Betsy DeVos meets with men's rights activists article on Think Progress, which in turn leads us to another article from the Pacific Standard, and this one's called Silencing Women Inside the National Coalition for Men. By outing rape accusers, the organisation is poisoning the dialogue on campus sexual assault. So it seems the Think Progress article has got a lot of its information from this article from the Pacific Standard, which seems to be a social justice news website. Now, unfortunately, this article does not link to the particular page which has the photos of the alleged false accusers. But we know from the Pacific Standard article that the chapter which supposedly published the allegedly false accusers is the National Coalition for Men's Carolinas chapter. So let's go have a look at their web page. And by the way, Cenk, if you ever watch this video, which I doubt you would, this is what you should actually do when you're pretending to do journalism. You should actually go and check sources and citations and see if they're legitimate. Just a word of advice. So having a look at the NCFM Carolinas page, I can't find any pictures of false rape accusers, or allegedly false rape accusers. There is definitely a lot of information about campus rape allegations and Title IX. There's a section on student lawsuits. There's a section on exonerations. So these are people who have been accused and proven innocent. And there's a video here, freed after 18 years. I wonder what you think of that, Cenk. And he's a black man too. A lot of these men seem to be black. I think Cenk would agree with me that black men have a raw deal in the legal system. Right, Cenk? Although it's not just black men, I should point out, it's men in general. There's a section about different universities, but once again there's no photos of accusers. There are links to articles on other news sites. I'm guessing some of those articles may have pictures of women who have made accusations of rape, but surely linking to articles on other news sites wouldn't be what the Pacific Standard would be referring to. At least I hope that's not what they're referring to. Let's continue our look at the NCFM Carolina website and see if we can find these pictures of women making false allegations. There's facts about sexual assault. There's a section on affirmative consent. There's a section on men's issues, resources. I can't find any pictures of women who have made false accusations or are accused of making false allegations. So the Pacific Standard article came out November 13th, 2014. So that's almost 3 years ago. So I have to wonder if the author of the Think Progress article attempted to check the citations from the Pacific Standard article. I'm guessing Casey Quinlan didn't. I'm guessing she just read the article and took it as fact, didn't check to see if the allegations towards the National Coalition for Men Carolinas is true. I mean, why would you, right? Why would you actually do journalism when you're being paid for it? That's crazy. And I can guarantee you that Cenk didn't. So the answer is I don't know. I don't know if the National Coalition for Men Carolinas did have pictures of false accusers or pictures of women who were allegedly false accusers. Cenk doesn't know either, and neither does the author of the Think Progress article, which Cenk is getting all his information from. The point is, though, if they did do it, if they did have pictures of false accusers or allegedly false accusers, they don't anymore, as far as I can tell. Unless they have a different website somewhere else with the false accusers, which I haven't been able to find. Once again, this is hard to say because the Pacific Standard article doesn't actually link to any evidence. How convenient. Let's continue.
I mean, if you're going to go down that road, which I would never go down because I think it's a dangerous and bad idea, you better make sure that you come correct. And are you sure the National Coalition for Men has made absolutely sure that all these cases are adjudicated? Let me assure you that I am not positive about that.
Let me ask you a very, very simple question, Cenk. Has the Young Turks ever published a picture of a person accused of a crime who has not stood trial? The answer is yes. In fact, you guys do it all the fucking time, right? Which is fair because it's news, right? Someone is arrested for a particular crime. You then see their picture on a online publication because, you know, you don't do any actual journalism yourself. You just read online articles. So you see their picture on an online article and you read the article and talk about how this person's been arrested, etc., etc. So my next question for you, Cenk, is if the NCFM Carolinas did actually publish these pictures, where do you think they got the photos from? Do you think they hid in the bushes outside their house and took photos? You probably do, right? But wouldn't a more reasonable explanation be that they got the photos from online news publications? You know, exactly the same thing you guys do all the fucking time, right?
Look, the men's rights movement, I'm a man, right? So why would I be against men's rights? Because I'm not against men's rights, nobody is. Men already have a lot of rights.
Men already have a lot of rights. Wow. Guess what, Cenk? Women already have a lot of rights. Black people already have a lot of rights. Gay people already have a lot of rights. Now, that doesn't mean that those groups, and including men, don't have social or legal issues. Just because all those groups already have a lot of rights, to quote you, doesn't mean that there aren't legal or social issues that need to be addressed. Next.
So, see, the way that it worked was we had all the rights in the beginning.
Oh, really? Men had all the rights in the beginning. So, Cenk, can you tell me, please, what year was it that men gained the right to bodily integrity? Can you give me a year? Can you give me a date, please? Could you give me a citation? Could you let me know when male circumcision became illegal? I'm just curious, mate, because we still don't have that right, as far as I know, unless it's been changed in the last week or so, and no one told me. It's 2017, and we're still missing that basic human right. Nice try, though. Nice try. Continue, Cenk.
And then eventually, it spread out to more and more people. In fact, it was, of course, as you know, propertied white men and then non-propertied white men, and the list goes on and on of the people who got rights. So it's not like men needed someone to protect them because, oh my gosh, they've been discriminated against for such a long time. Now, if the pendulum swung too far and you can show a couple of cases here. In this divorce proceeding, you see how it is no longer equal. Okay, that's a good conversation to have, and I've had that conversation. And as it turns out, men's rights groups don't really stop there.
How would you know, Cenk? How would you know that we don't really stop there? I mean, all you do is you read progressive bias articles online who use pickup artists as examples of men's rights activists.
So, unfortunately, in this one case, this was the definition of fake news.
When pickup artists actually aren't MRAs at all. But you don't care. You present them as MRAs anyway, right? Because it's a good argument to make against us.
Terrible, shoddy journalism.
Well, it's a good argument if you don't care about facts and the truth, of course. In other words, it's good propaganda, right, mate? Now, it is true that you did talk to Karen, but I seem to recall you yelling at her to make you a sandwich at one point.
Stop voting and go make me a ham sandwich.
Right? You weren't really rational during that conversation, were you, mate? But, continue, because you have to create a straw man to derail the conversation about due process. Do you notice that we're no longer talking about due process now? That's why I made that point really early on, because the rest of it, not so much about due process, which is the actual focus, well, should be the focus of the video. But continue, Cenk, continue.
The more you get in the weeds, the uglier it gets. And talking about how women had this coming and that coming, and they've been taking away our rights forever. Taking away your rights? No, you have to show very specific examples. Otherwise, you're the ones who started with all the rights in the first place, and that includes me.
What about the right to a fair and equal trial, Cenk? What about that right? Due process. Because as it is, in the court system, I'm not even talking about the university kangaroo courts, which should be the topic of this video, but I'm talking about the legal system in general. Men get treated far more harshly than women, twice as likely to get a conviction, 63% longer sentences. Now, I know you have a problem with that when it's black men, and, that's a fair argument, right? But for some reason it doesn't count when the men are white. Even though a white man being convicted of the exact same crime as a black woman is more likely to serve jail time or get a longer sentence. Because gender is a bigger factor than race. You're perfectly okay with race being a factor, but you're just fucking clueless when it comes to gender, right? You're a fucking idiot. You're an ignorant fucking idiot. And a hypocrite.
Just read history, any history, but obviously some people are not enamored with facts. This is referring still to the National Coalition for Men, okay? In 2012, the group supported the Republican House version of the Violence Against Women Act, which removed protections for LGBTQ people in crisis centers. The group has been very litigious when it notices events specifically designated as for women. Its members sued a strip club for letting women in for free during its ladies' night, and sued a company called Chick CEO for not letting men into a women's networking event. Look, I'm not sure I want to bust into a women's networking event, but if you thought that the CEO of that company and all the executives were women and men did not have a right, did not have a good way to advance in that company, as women have had that problem in many industries for a long, long time, but it happened in that particular case and you want to pursue that, I understand. You'll have to prove your case in court, etc. But now we're getting into suing strip clubs for ladies' nights? I mean, my conservative friends, wouldn't you call that a snowflake?
Are you suggesting that the National Coalition for Men is a conservative organisation? To my knowledge, they don't have any political leaning or affiliation. I guess you consider everyone who isn't as progressive as you to be a right-wing extremist, though, right, Cenk? I guess everyone to the right of you is a extreme right-winger, right? Which means just about everyone. But what about the strip club? Or let's talk about bars in general. Now, there is a good reason why bars offer cheap drinks or free entry to women. It's a financial reason. If you can entice more women to come to your bar, then in turn you typically get more men who go there to try to pick up the women. So the reason why bars do this is financial. It's a business decision. Now the question is, should a bar be able to discriminate if it's in the best financial interest of the bar? And that's really what the issue is here. Now, the way Jenk sees it, it's a minor thing, it's of no consequence. And I would agree to some extent that there are far more important issues to tackle than free entry or free drinks for women. But it is still a case of discrimination. Let me give you a scenario, Jenk, that you might understand a bit better, right? Imagine there is a bar or a nightclub which has a lot of black clientele, a lot of patrons who happen to be African American. And around the same time, there's a lot of bad publicity about drug gangs and African American crime and things like that. So the bar decides to give free entry to white people, or cheaper entry, but charge black people more in an attempt to get more white clientele coming in and less black clientele. They figure this might help improve the bar's image, etc., etc. You get the idea. Would you be okay with that, Jenk, or would you maybe do a video on it? I imagine you would do a video saying this is racism and it's wrong and it's discrimination, and I would agree with you, it is discrimination, and you would be perfectly right in calling it out. What is the difference, though? Can you explain to me what the difference is, apart from the fact that you think men already have all the advantages and it's only non-white men who deserve any kind of recognition of their issues? Next.
Like, you were so bothered that you couldn't get free night at the strip club and they only had it for ladies, and you don't see the logic in that? And you say, oh no, I gotta have equality at the strip club. Men have never had equality at strip clubs, and now we need it. You see, when you make a case like that, it makes everybody think you're a jackass.
What about due process in university kangaroo courts, Jenk, when it comes to rape accusations? What about that one, mate? Can we talk about that? Can we talk about that without all this fucking derailing and fucking character assassination and all the other shit that you do all the fucking time? Can we actually go back to the serious topic which you are avoiding? It's ironic that you accuse MRAs of talking about nonsense and bullshit and unimportant things when you are avoiding the actual fucking topic. You're doing this because you know you don't have a fucking case. Pathetic.
Okay, certainly makes me think that, and I suspect a large portion of the audience. But actually, the one that's most harmful is going after LGBTQ rights. If you're for men, why do you care? Gay men, straight men? I thought you were for equality. All of a sudden, it looks like you're not for equality, and so you've got other agendas.
Speaking of false allegations, this is a good one right here, Jenk. You just made a false allegation against the National Coalition for Men. Well done, mate, well done. Now, once again, Jenk's misinformation starts with the Think Progress article. The Think Progress article, as a citation, uses yet another Think Progress article. This one is called Misogynistic Men's Rights, in talking marks, Group Endorses GOP Version of Violence Against Women Act, from May 16, 2012. So the quote from the National Coalition for Men is this.
Those opposing H.R. 4970 loudly assert that VAWA serves all people, which is absurd on its face given the name of the act. Opposing versions, by omission and lack of specificity, generally exclude men, particularly heterosexual men, regardless of specious arguments to the contrary. We cannot adequately address violence-related issues by excluding half of the population, allowing precious resources to be squandered for ideological purposes, empowering false accusers at the expense of the true victims, and letting malfeasance and maladministration to run unchecked without holding applicable administrators accountable.
Okay, so it's pretty clear that this is not anti-gay. What it's trying to say is that men in general should have resources, as opposed to only certain men who belong to certain groups. Now, I can give you an example of this from England. When we're talking about domestic violence beds in England, there are 4,000 beds for females. They're the ones in red that you're seeing on your screen here. Now, that's compared to 15 places for males and 18 places for gay males. Now, the question I have to ask is, are there more gay men who are victims of domestic abuse than straight men? I would suspect that the answer to that is no. So the question is, why isn't there more places for straight men? That doesn't mean that we're trying to take away places for gay men. It's just asking the question, why aren't there more places for straight men? Or maybe another question we could ask is, why is there specifically places for gay men? Why aren't there places just for men in general? If you're a victim of domestic abuse, does it really matter if your partner is male or female? Couldn't we just have places for men in general? And if you're gay or straight or bi or whatever, you can turn up and use those places, right? That would be fair. To my knowledge, there aren't domestic violence shelters for women who are divided up into straight women and gay women or lesbian women. To my knowledge, they're all just lumped in together, which makes sense to me. But this all comes from the type of thinking that if you're a male and you have an issue, you're only allowed to have that issue or to talk about that issue or for that issue to be acknowledged if you belong to a specific group. So if you're male and you're black, or you're male and you're gay, or you're male and you're trans, or whatever, then it's fine. Your issue can be acknowledged, and you're allowed to have resources, etc., etc. Not as many as straight white women, of course. That would be crazy. That would be misogynistic and patriarchy, wouldn't it? But if you happen to be a straight white male, then apparently you don't count, even if you're a victim of domestic abuse, right? You just shouldn't get resources or as many. Once again, not trying to take away anything from gay people, just trying to have more resources in general for men in general. It's that simple. And Cenk would actually know this if he did all of 5 minutes of actual journalism.
So now let's look at the reality of the stats here. Researchers estimate that somewhere between 2 and 10% of rape allegations are false, but even among those who are falsely accused, it's rare for men to end up in prison as a result. So
now, it just so happens while I was on the National Coalition for Men Carolina's website before, I clicked on a link just randomly, and by pure luck that link was debunking this 2 to 10% statistic. So let's have a quick look at that article.
That only 2 to 8% of rape accusations are false stat is extremely misleading. The linked academic study actually concludes that false rape allegations occur at a rate of 2 to 10%, but leave aside the typo. Readers could easily interpret the above paragraph to mean that when a woman files a complaint about sexual assault, then an assault did in fact occur over 90% of the time. That interpretation is wrong. A false rape allegation is provably false, meaning, for example, that the accused has a bulletproof alibi or the accuser eventually recants. In many of the cases examined by the authors of the study, there was simply not enough evidence to bring charges. A rape might have occurred, but it might not have. Such cases are not classified as false. Specifically, in their analysis of sexual assault cases at a large university, the authors found that 5.9% of cases were provably false. However, 44.9% cases did not proceed, meaning there was insufficient evidence, the accuser was uncooperative, or the incident did not meet the legal standard of assault. An additional 13.9% of cases could not be categorized due to lack of information. That leaves 35.3% of cases that led to formal charges or discipline against the accused. So there is obviously a lot of uncertainty here, a lot of he said, she said when allegations are filed. It would be a mistake to conclude, on the basis of the existing evidence, that 9 out of 10 assault claims are genuine.
Now, I'll tell you what I'm going to do. I'm going to be really, really generous to Cenk here. You just heard the 2 to 8% figure debunked, but I'm going to be really generous and say, let's assume, for the sake of argument, that Cenk is 100% correct. Somehow the universities managed to detect every single false allegation, I don't know, using patriarchy, penis magic or something, and not a single false allegation slips through the cracks. Let's imagine that there isn't a grey area where we simply don't know if a case is legit or false. Let's, for the sake of argument, say that that 2 to 10% figure is carved in stone, right? Best case scenario for Cenk here. Now imagine there was a similar figure for African American men who were arrested by cops. Let's imagine that 2 to 8% of African American men who were arrested by the cops were taken out the back of the police station and brutally beaten. I have to ask the question then, Cenk, would 2 to 8% be a really small number, or would that be 2 to 8% too many? Simple question, mate. What if, for argument's sake, there was a figure, say, 2 to 8% of women in the workforce were sexually harassed by their bosses? Would that be an incredibly small number, Cenk, or would that be 2 to 8% too many? Once again, it's a simple question. Now keep in mind, 10%, that means 1 in every 10 cases. I don't know how you can say that's an insignificant number. And once again, this is giving you the best case scenario. It's not taking into account all the cases which are in that grey area where we simply don't know if they're true or false. Anyway, continue.
That doesn't mean that if you're in that 2 to 10% that what happened to you isn't outrageous. It is, man. Being falsely accused of rape is a terrible, terrible thing. But is it an overwhelming problem that needs to be addressed at the same level as actual rape and sexual assault?
The point here, Cenk, is due process. It's something that everyone should have. And an accusation of rape suddenly doesn't make that disappear. I fully agree. Anyone convicted of rape, after having a proper trial and having actual evidence to convict them, of course, should be thrown in jail. Rapists should be punished. No doubt about that. But that doesn't mean that we take away due process to get that result. Because when you do that, you open the door to injustice. You open the door to the system being abused and misused.
Well, I want the appropriate resource to go into both problems, but appropriate also means proportionate. So if you call that 50-50, then the stats don't back it up.
Due process for everyone, Cenk. That's it. End of story. There's no argument for due process being proportionate. Okay? That's the standard for everyone. We don't say, hey, we're not having due process in these certain cases because we believe that the majority of people making the allegation are telling the truth. What we do is we have due process in every single case with every single allegation, regardless of who is making the allegation and regardless of what the allegation is. Well, at least that's what we should have. So your proportionate argument is fucking idiotic.
In fact, let me give you the other side. For students who were found responsible for sexual assault, only 30% were actually expelled, according to a 2014 Huffington Post analysis of data from over 100 schools. So,
the good old bait and switch tactic, huh? It's a common tactic used by people like Cenk. I've seen Steve Shives use it more than once. They tend to use the terms rape and sexual assault as if they're interchangeable. Now, all rapes are a form of sexual assault, but not all sexual assaults are rape. Sexual assault is an extremely broad category, an extremely broad term. On one extreme, we have things like rape, which are obviously very, very serious. But on the other end of the the sexual assault spectrum, we have less serious crimes like grabbing someone on the ass without permission or kissing someone without permission. Now, I'm not saying these things are good. I'm not suggesting people should go around doing them. I'm just simply pointing out the fact that they're not the same as rape. So 70% of sexual assault convictions at universities don't end in someone being suspended or kicked out of the university. Yeah, I would argue that if someone grabs someone on the ass without permission, they shouldn't be kicked out of university. I would argue they shouldn't go to jail either. Once again, I'm not saying it's acceptable to go around grabbing people on the ass without their permission. I'm simply making the point it's not in the same fucking category as rape. So we don't see these sexual assault figures broken down into different forms of sexual assault. What percentage is towards the rape extreme end of the scale? And what percentage is towards the grabbing someone on the ass end of the scale? We don't know, do we? But Cenk wants you to think that 100% of them are on the rape end of the scale, because that's the only way he has an argument here. It's convenient for him to mix the terms rape and sexual assault and to try to make them interchangeable as if they're exactly the same thing. It's extremely dishonest.
You have a huge problem of campus rape and sexual assault, and most of the people who do it unfortunately get away with it. And there's not enough resources to track down and make sure that there's justice in that system. On the other hand, you have a small percentage of people who are falsely accused of rape, and they hardly ever actually go to court and go to prison. So it doesn't make the individual cases any less unjust, but is that the same scope of problem as the sexual assault in the first place? No, the numbers show you that it is not. So just have a sense of proportion here.
Or we could give everyone basic due process rights regardless of what they're being accused of and who is making the allegation. Why don't we fucking try that, Cenk? How about that for a fucking concept?
Now we go to the National Coalition for Men president. That's Harry Crouch, president of National Coalition for Men. He has also vocally blamed survivors for the abuse they faced. In a 2014 interview with Pacific Standard, Crouch defended Ray Rice, a former football player who was indicted in 2014 on third-degree aggravated assault for an incident involving his then-fiancée. Now, before I go to his defense, you guys remember that incident? And we showed the video here. I don't want to keep re-showing it, but he knocks out his fiancée. At the time they were fiancé, now they're married. And it is a brutal looking video. And then he drags her out of the elevator, leaves her shoe there. After he knocks her out, he doesn't even look at her for a long time. I mean, it is stomach turning violence. But no, Harry Crouch's vision of that, or perspective on that, was vastly different. He said, I'm not saying he's a good guy, but if she hadn't aggravated him, she wouldn't have been hit. They would say that's blaming the victim, but I don't buy it. What's there not to buy? I mean, you could disagree on what happened, although the videotape is incredibly clear. But when you say she aggravated him, you're blaming the victim. There's nothing to buy or not buy. You could say you're justified in blaming the victim. You would be among a really, really small minority of people who think that. But you can't say you didn't blame the victim because you just blamed the victim.
So we have two things here. The first thing is a little bit of quote mining by Think Progress. Very good. You know, nothing like selective quotes and taking things out of context when you're creating propaganda, right? And the second thing we have here is Cenk being such an incredibly lazy journalist that he didn't go and check to see what the full quote was and its proper context, because, you know, that would actually take a little bit of effort, and we know Cenk is a busy man. He's a busy man ranting and raving at articles he's read online without doing any research. It's a very time-consuming thing. He hasn't got time for real journalism. That would take a bit of effort. So, once again, I'm doing Cenk's job for him, and I'm going to follow the citations once again to the Pacific Standard article, and here's the full quote.
Take Ray Rice. You look at the videos, What you're gonna see is that he and his fiancée at the time were in a parking garage. She actually attacks him, she smacks him, hits him on the chest or something. In the elevator she attacks him again. Then this idiot cold-cocked her. Should he have cold-cocked her? No. But all the conversation on the media for 24 hours was how bad he was, nothing she did. As though she didn't participate. I tried to steady the boat, but, I mean, that's just playground logic. You realize we're talking about a 200-pound man assaulting a woman less than half his size. Can we really claim self-defense here? You simply can't scapegoat one participant just because he has the penis, Crouch said. If a little person without a penis instigates, she will never be accountable for her actions. I still don't understand how you can see this as a fair fight, I said. You're actually defending Ray Rice? I'm not saying he's a good guy. But if she hadn't aggravated him, she wouldn't have been it. They would say that's blaming the victim. But I don't buy it. In any way, football is always happy to put on pink suits to celebrate women. Why can't they have a week, or just one day, where they celebrate men?
Now, I'm a pretty big guy, but I'm nowhere near the size of American football players. So imagine I went up to Ray Rice and I started smacking him around the face, and he punched me and knocked me out. Do you think there is anyone who would have any sympathy for me? Do you think a single person would be saying Ray Rice was in the wrong, or do you think they would be saying, hey, Bain should have kept his hands to himself in the first place? And you know what? They would be right in saying that. It's a simple rule. If you don't want to get hit, don't go around hitting people. And the fact that his wife thought she had the right to smack him about with no consequences is something we should be talking about. Now, there is also an argument that he overreacted, which is what Harry Crotch actually said when you read the full quote, in context. Cenk would know this if he did his job as a journalist. Sorry, his pretend job as a journalist.
So the more you get in the weeds, the more you get a sense of where these guys are actually going, and it is not good news, man. It's in a really, really bad direction. So that's it, Cenk. That's your case against us. Misquotes and mischaracterizations and straw men and a lot of derailing away from the actual topic, which was due process for everyone, Cenk, regardless of their gender. Regardless of the gender making the accusation, right? That's what the topic actually was. That's what the point actually was. Instead, you're reading quote mines of comments from Harry Crotch so you can mischaracterize him and somehow derail the conversation. Top-notch propaganda, mate. Really top-notch. Now our education secretary is like, oh yes, 50-50. I meet with people who suffered rape and sexual assault and the people who care about them. And I meet with people who think that is a made up issue and that they kind of had it coming a little bit sometimes in some assault cases.
Wow, that's a pretty big leap right there, Cenk, don't you think? Talk about exaggeration. Wow.
No. Okay. Well, when you look into the history of Betsy DeVos, you realize that we shouldn't be surprised by this. Why we fought her, because we didn't think she was right for that role. Well, it turns out the Dick and Betsy DeVos Family Foundation made donations totaling $25,000 to Foundations for Individual Rights in Education, which has shared articles dismissive of sexual assault survivors. One read, unfortunately, much of the feminist war on rape has conflated sexual assault with muddled, often alcohol-fueled sexual encounters that involve miscommunication. You call it rape, I call it miscommunication. They gave money to that cause. So now are you surprised that Betsy DeVos is meeting with people who are for men's rights to protect men from the miscommunication that happens when they're in what they admit are alcohol-fueled sexual encounters? Look, people.
Did he just imply that quote was from MRAs? It certainly seemed that way.
People being drunk and having sex oldest time. When someone is knocked out unconscious from drinking, yes, that's rape. And that is not a 50-50 question. That is a legal question, and it is settled. The fact that we are now relitigating this at the Department of Education is horrific.
Now, the quote said nothing about someone being passed out drunk. But you see, Cenk has to jump to the most extreme example to make a case. He even admits sex while drunk is a very, very common thing. It's always happened, as long as, I guess, there's been alcohol, of course. But he has to jump to the most extreme conclusion to paint the worst possible picture he can of his opposition, even though the quote said absolutely nothing like that. The quote that he kind of attributed to MRAs, which is interesting, as we're about to see. So once again, I did Cenk's job for him and traced the quote back to the original article. It's called "The Politics of Campus Sexual Assault." Oh, that's interesting. It's written by Kathy Young. Kathy Young is a feminist. Cenk? Geez, you really fucked up that one by trying to attribute the quote to MRAs, didn't you, mate? You just fucking shot yourself in the foot with that one. But anyway, it's a well-written article from 2011, and it starts off talking about a case from North Dakota about a student called Caleb Warner who was falsely accused of sexual assault, and he ended up getting a 3-year ban from the university. Now, it turns out that his accuser was later on arrested by the police and charged with filing a false report after concluding their investigation into her. That's interesting, isn't it? But the really interesting point of the article, or I should say the relevant point of the article, is the last couple of paragraphs. So let's have a quick look at them and see if Kathy Young is talking about people who are passed out drunk being raped, or whether she's talking about drunk sex.
Sexual violence on campuses is a real problem that, until fairly recently, was usually treated with not-so-benign neglect. Yet Washington's push to force colleges into taking a more aggressive stance is based on the highly inflated notion of an epidemic of campus rape. The OCR letter cited the recent campus sexual assault study, commissioned by the National Institute of Justice, as evidence that 1 in 5 female students experience rape or attempted rape while in college. Yet the vast majority of the incidents in the study were related to incapacitation by alcohol or drugs rather than physical force, and incapacitation was defined so broadly as to include impaired judgment. Not surprisingly, most of the women labeled as sexual assault victims did not see themselves as such, did not feel traumatized, and did not report the alleged offense because they did not consider it serious enough. Unfortunately, much of the feminist war on rape has conflated sexual assault with muddled, often alcohol-fueled, sexual encounters that involve miscommunication, perhaps bad behavior, but no criminal coercion. As a result, the drunken hookups all too common on today's campuses can lead to devastating charges and penalties. The accusations against Caleb Warner reportedly stemmed from such an encounter as well. Should colleges promote responsible sexual conduct? Of course, but not by irresponsibly misusing charges of rape or trampling the presumption of innocence.
Well, look at that. It turns out she was talking about drunk sex, and not people passed out being raped. Once again, Cenk is full of absolute fucking shit.
DNA evidence and some UC students helped free a man wrongly accused of rape 18 years ago, and now he's fighting to make sure others get a chance to also clear their name. News 5's Eric Flack is live with our number 3 pick tonight. Eric?
Sandra, after fighting for almost 2 decades to clear his name, today Robert McClendon started his fight to change the system.
They just didn't believe.
8 days ago, Robert McClendon walked out of a Columbus jail after almost 18 years behind bars. serving a possible life sentence for the kidnap and rape of a 10-year-old girl. DNA testing now shows McClendon didn't do it.
The first night I stayed at home, I got up at about 4:30 in the morning and just walked outside and just turned around in circles and just looked up at the sky.
It was a moment McClendon feared he would never see. From day one, he professed his innocence, even turning down chances at freedom because of what the parole board wanted in return.
They said, well, you can get out early release, Mr. McClendon, if you agree to a comprehensive sexual offenders program. You have to admit guilt. And I couldn't do that. I wouldn't do that.
3 times McClendon's petitions for DNA testing were rejected. But in 2006, lawyers from the Ohio Innocence Project in Cincinnati took up his case and got the DNA testing he wanted. It showed fluid found on the victim's clothes wasn't his.
To have the ability to revisit that.
Today, McClendon testified in front of a state Senate committee considering a law that would make DNA testing more accessible to inmates.
There's people in prison that are locked up for crimes they didn't do. I know that because I was there. And somebody has to speak for him, and who better to speak for him than me?
A man who missed his children growing up, his parents passing away, and now can only try to make up for lost time.
The Ohio Innocence Project here at UC has asked that same DNA testing facility that cleared McClendon to review evidence in about 30 other cases, believing McClendon will not be the last to be exonerated. Reporting live from UC, Eric Flack, News 5.
Terrible, shoddy journalism.